କିଛି କାମ କରିବା ପାଇଁ ଯଦି ଆପଣଙ୍କୁ prohibit କରୁଛି, then that is called a temporary, and that is called an injunction. So injunction is nothing but an order of a court who is competent enough to pass that order, and that order is in regards to what? In regards to directing a party to perform a certain act or not to commit a certain act. So that is what injunction is. So without wasting time, let's just proceed to our discussion today. Temporary injunctions and interlocutory orders both are dealt under Order 39. Today we'll only deal with temporary injunctions, and tomorrow we'll discuss the interlocutory orders. So temporary injunctions, before going to temporary injunctions, let's just know what is an injunction. As I discussed, it is an order to do or refrain from doing a particular thing. So basically, when a court passes an order and asks you to do a certain thing or not to do a certain thing, that is called an injunction. That can be of the object basically of that injunction is to make sure that the property or the the main disputed property that is there, it must not be wasted or it must be preserved until the suit is decided. କାହିଁକି ଇଞ୍ଜେକ୍ସନ ଟା ଗ୍ରାଣ୍ଟ କରିବା ଦରକାର କି କାହିଁକି ଗ୍ରାଣ୍ଟ କରିବା ଦରକାର ନାହିଁ, କେତେବେଳେ କୋର୍ଟ କାହିଁକି ଡିସାଇଡ୍ କରନ୍ତି ଗ୍ରାଣ୍ଟ କରିବା ପାଇଁ ଇଞ୍ଜେକ୍ସନ? ଦି ମେନ୍ ରିଜନ ଇଜ when court sees, suppose our example ରେ ମୁଁ ଗୋଟେ ମୋର ପ୍ରପର୍ଟି ଟେ ଏବେ ମୋ ନାଁରେ ମାନେ ପାର୍ଟିସନ କରିବା ପାଇଁ ହଉ କି ଯାହା ବି ହଉ ମୁଁ ଗୋଟେ ସୁଟ୍ ଟେ କରିଛି. In the meantime, I am seeing that my brother, who is also a party to that suit, is trying to dispose of that property, which against which I am filing the suit. If that has been done, and in that case, if he is successful in doing that, then probably till the end of the suit there will be nothing left. Suit ସରିଲା ବେଳକୁ ଆଉ କିଛି ଥିଲେ ଯେ ରହିବ, ପ୍ରପର୍ଟି ତ ସେ ବିକି ସାରିବଣି, ସେଠି ଆପଣ ବୋନାଫାଇଡ୍ ପର୍ଚେଜର ର ଇଣ୍ଟରେଷ୍ଟ ହ୍ୟାମ୍ପର ହବ, so you have to compensate that. So that takes a lot of time and effort. So to save the parties from all those time and effort, it is made sure during pendency of the suit, if there is any question or there is any situation arises where it is needed that the property in dispute is to be preserved, then the court may order to do a certain thing in respect of that property or not to do a certain thing in respect of that property. So that is what an injunction is. Types of injunctions are, according to the nature, they can be mandatory or they can be preventive. What is a mandatory injunction? That is when the court directs to do a certain act. So basically, when it is said that you demolish the building that has been constructed. Example is, court is said that suppose a mo land re ଏବେ ଘର ତିଆରି କରିସାରିଲେ, ତ ଏବେ ମୁଁ ତାକୁ ଯେତେବେଳେ ଇଞ୍ଜେକ୍ସନ କରିବି, mandatory injunction କରିବି ଯେ ମୋ ଘରରେ କେମିତି ତମେ କରିଦେଲ, ମୋ land ରେ କେମିତି ଘର କରିଦେଲ. So a mandatory injunction will be issued in directing to perform a certain act, that is to demolish that house that has been built by B. It can also be preventive. Preventive mane kono? That is a direction to refrain from committing a certain act. So basically, if the party B is encroaching in the property of party A, now the court can direct that you are hereby prevented from entering into the land of A. So there, a preventive injunction is coming into force. These are the types. And according to the time period, they can be again of two types, that is perpetual and temporary. We are not concerned with the perpetual injunction right now, but let's just know that perpetual injunction is dealt under Specific Relief Act, section 38 to section 42, whereas temporary injunction has been dealt under Order 39, Rule 1 to Rule 5. There comes a question many a times in exams, what is the difference between perpetual or permanent injunction and temporary injunction? So if in that case, what will be your answer? That perpetual injunction has been covered under section 38 to 42 of Specific Relief Act. Here in temporary injunction, it is covered under Order 39, Rule 1 to Rule 5. Perpetual injunction is for all time. So once it is granted, it is to last till forever. But in temporary injunction, it is for a certain period only. That is until disposal of the suit or further order. ଯାହା ବି ସେଥିରେ ଦିଆ ହେଇଥିବ until disposal of the suit or further order ସେଇଟା ରହିବ. The perpetual injunction ରେ it is generally given after conclusion of the trial. But here it is not given after conclusion of the trial. It is given during the pendency of the suit in temporary injunction. In perpetual injunction, it is usually given by decree. First, ମାନେ ପୁରା ସବୁ hearing ସବୁ ସରିଲା ପରେ judgment ହେଇକି decree ରେ ଆପଣ permanently injunct କରିବେ. But ଏଥିରେ temporary ରେ କିଛି decree ହେଇନି. By an order you are doing that. In the perpetual injunction, it is concluding the rights finally. But in the temporary injunctions, it is not concluding the rights finally. In fact, it is a limited purpose by and limited period. So it is not conclusively determining the rights. Conclusively, right it is served. So these are the types and these are the difference. Now we'll move to our main moot of today, that is temporary injunction. That is dealt under Rule 1 to Rule 5 of CPC. Rule 1 to Rule 5 of Order 39 of CPC. So let's just know who can apply. Both parties can apply. So there will be a general presumption that only plaintiff can apply. No, it is not as such. Both parties can apply. Plaintiff can apply. If the defendant thinks that now the plaintiff is trying to encroach in his property, he can also apply. There is no such bar. The parties to the suit, they may apply. That is given. Against whom it can be issued? It can be issued against any party to the suit. So the injunction is against a party. Why? Because that party was trying to do a certain act which you were trying to prohibit, or not doing a certain act which you want him to perform. In that case only you are applying for before the court to issue an injunction. So here it will only be issued against a party, not against a stranger or a third party. It is also to be noted that it cannot be issued against a court or a judicial officer. So ଆପଣ କୋଉଟେ court କହିପାରିବେନି ଯେ you do this act in this manner. No, you can't do it. So ଆପଣ କହିବେ ଯେ it is the high court जो direction ଅଛି, that is a direction, but that is not an injunction. So it is a direction, but the court and judicial officers you cannot put any injunctions against. You cannot also put any injunctions against a stranger or a third party. Grounds. Grounds is given under Rule 1 to Rule 2. These are the 7 grounds. If any of which comes, then the court may very well grant a temporary injunction. What is the first ground? That any property in dispute in a suit is in danger of being wasted, damaged, or alienated by any party to the suit. ଏଇ ଯୋଉ example ଦେଲି ଯେ partition suit ରେ ମୁଁ କରିଥିଲି, now my brother is trying to alienate the same property. If it is alienated, then will I be in a position to get a partition in respect of that? Because it has already been purchased by a bona fide purchaser. So in that case, I can apply before the court for a temporary injunction. That is the first ground. Second ground, if any such property, what is any such property? That means any property in dispute in a suit. So basically, first point आपण जानिବାକୁ पड़िबो that से जो property टा against which you are trying to obtain a temporary injunction, that must be in dispute to a suit. आपण ଗୋଟେ random को property against रे injunction करि परिबो. There must be a property which is in dispute in a suit and that was in danger of being wasted, damaged, or alienated by any party to the suit. That is the first ground. Second is, there is a property, it is in dispute in a suit, and that property is wrongfully sold in execution of a decree. ଏବେ ଗୋଟେ ଆର ଏକ୍ସାମ୍ପଲ କଣ, ଆପଣ ଏବେ ମୁଁ ସେଇ ଯୋଉ ପାର୍ଟିସନ ର ସେଇ ଗୋଟେ ଏକ୍ସାମ୍ପଲ ଆମେ ସବୁ ଦେଖିବା, ସେଇ ମୁଁ ପାର୍ଟିସନ ଗୋଟେ କରିଥିଲି ଗୋଟେ ଜାଗା ହିସାବରେ, ଜାଗା ଏଗେନ୍ଷ୍ଟ ମୁଁ ପାର୍ଟିସନ ପାଇଁ କରିଥିଲି। ଏବେ ସେ ଜାଗାଟାକୁ ସିଏ ମୋ ବଡ ଭାଇ ଯେହେତୁ ଗୋଟେ କୋଉଠୁ ଗୋଟେ ସୁଟ ରେ ହାରିଥିଲା, ସେଠି ସେ କଣ କରୁଛି ନା ସେଇ ସେଠି ତାକୁ ଆଟାଚ ହେଇକି ଏକ୍ସିକ୍ୟୁସନ ରେ ଆଟାଚ ହେଇକି that is being sold. So in that case I will not be in a position to get a partition in respect of the present property. So ସେଇଠି ମୁଁ କରିପାରିବି, କୋର୍ଟ କୁ ଆପ୍ଲାଏ କରିପାରିବି that देखो एठी से जाई से जो प्रॉपर्टी टा एठी अछि सेटा को से एग्जीक्यूशन रे सेल करिया को जाउछि. So I can apply before the court to prohibit him from doing that. Third ground is if the party is threatening to dispose or remove such property with intention to defraud the creditors. That means ଏବେ କଣ କରୁଛି ସେ ଖାଲି କହୁଛି ଦେଖେ ମାନେ କରିନି କିନ୍ତୁ ସେ threat କହୁଛି ଯେ ମୁଁ ଏବେ ବିକିଦେବାକୁ ଯାଉଛି. ମୁଁ ସବୁ ଗୋଟେ ଏବେ ରେଣ୍ଟ ରେ ରହିଛି ଗୋଟେ ଘରେ ମାନେ ଗୋଟେ ଦୋକାନ ଘରଟେ ନେଇକି ମୁଁ ଦୋକାନ ମୋର କରିଛି. So it is my permanent. ମୁଁ ତା ଦେହରେ ବହୁତ ଗୁଡେ ଡେଭଲପମେଣ୍ଟ କରିଦେଲିଣି. ମେଡିସିନ ଷ୍ଟଫ୍ ଟେ କରିଥିଲି ତ ତାର ମୋର ଯାହା ବି permanent fixtures ବହୁତ ସାରା ଲଗେଇଲି. ଏବେ ମୋର ଯିଏ landlord ସେ ଆସିକି କହୁଛି ଦେଖ ମୁଁ ଏବେ ତାକୁ ମୁଁ ବିକିଦେବାକୁ ଯାଉଛି. So in that case, if there is a suit pending and I am thinking that he is threatening me to dispose or remove such property, then in that case that can be done. And of course, with intention to defraud the creditors. So the intention of defrauding the creditors must be there. Fourth is he intends to remove such property to defraud the creditors. First होची either threaten करूची or intention अछि to remove the property. Though से किसी ऐसी कोनी माने overtax करूनी, but there is an intention which I can very well see. He is not telling me that he will sell. माने आसी की डेली मते कोहुनी जे मु बिक देबी. But मु देखुची से buyers को सहित मिसुची, agents ମାନଙ୍କ सहित कथा होची, दलाल ମାନଙ୍କ सहित कथा हेलानी. So from that I am inferring that he intends to remove such property or dispose such property in order to defraud the creditors. Then also that is a fourth one. Fifth is if he threatens to dispose or otherwise cause injury in relation to any such property in dispute. Fourth is jodi se fifth is kona if he is threatening to dispose or otherwise cause injury in relation to any such property in dispute. ता माने से property को मु भांगी देबी मो एबे कहली जे जो घरटा अछि मु से घरटा मोर डिमोलिश कर. तो मु देखलेनी से मो घरटा भांगिलानी और मो पाचेरीटा को भांगी की ता देर ता रास्ता पूरा तयारी करिया बसले. So it is causing injury to my property. If that is done or खाली threat भी दोची नकरी भी खाली threat दोची तो मो तो पाचेरी भांगी की मु रास्ता तयारी कर. In that case also that is a good ground. Sixth is about to commit a breach of a contract or injury of any kind. जदि से गोटे breach of contract करिया को जाउची और other injury करिया को जाउची then in that case ता माने कोन मते कहितिला से घरटा बिकिया बे but से घरटा रबी की से आउडे काहा को बिकि देबो. Then in that case I can apply before the court injuncting him from selling that property to someone else. That is another ground. Seventh is any other ground as being fit by the court. So ethi auri jodi kichi ground the court can think of under which an injunction should be granted. So basically here discretion has been given to the court to because injunction cannot be put in a straight jacket formula. It has to evolve. So basically काली सकाळे जेतले आमे आपण इमेजिन करंतु 1950s रे when there was no computer was there a question of cyber fraud. So the cyber fraud रे किछि question नथिला. So एबे cyber fraud होउची. So in that case there एमती सेमिति injunction भी is a evolving thing. So आजी आ against होउची काली से intellectual property against भी injunction नहीं परिबो. There might be a different scenario altogether. So in that case it is making sure that only it is not kept limited to the grounds that have been given under Rule 1 and 2. Any other ground as deemed fit by the court, those grounds can also be taken up while applying for an injunction under this order and rules. Consequence, if all these grounds, ये जो 17 ground कहली, first होची कौन property is in dispute in a suit is in danger of being wasted, damaged or alienated. Such property is wrongfully sold in execution of a decree. Party threatens to dispose or remove such property with intention to defraud creditors. He intends to remove such property to defraud creditors. He threatens to dispose or otherwise cause injury in relation to such property. About to commit a breach of contract or injury of any kind or any other ground. ये जो 17 ground जदि हला, consequence would be that court may grant a temporary injunction to restrain such act or make such order for the said purpose as it thinks. Either say gote injunction dei paribo restraining such act or to directing him to perform such an act and or make such order. Basically, temporary injunction, it is only talking about restraining. It is not talking about committing a certain act. Mandatory injunction, in fact, is given under SRA, but I believe even though it is not given, but if it is necessary, because it is saying that if he may make such order for the said purpose that it thinks fit, there can be something done about it as well. So then comes the question, till when it will be uh, applied. That means once injunction is granted, till when it will be lasting. That is till disposal of the suit or further order. So ଯେତେବେଳେ injunction ଦିଆଯାଏ, normally court ଲେଖନ୍ତି till disposal of the suit or order of the further order of the court. तो ଯାହା ବି ହବ ଏଇ disposal of suit ପାଇଁ କରିପାରିବା or further order ପର୍ଯ୍ୟନ୍ତ ଆମେ injunction ଦେଇପାରିବା in temporary injunctions. Though the grounds are there that under which temporary injunctions can be granted, there are conditions which are to be satisfied before grant the injunction is granted. So a grounds ଗୁଡା ତ ଆପଣ ଦେଖିବାକୁ ପଡିବ ଯେ ଏଇ grounds ରୁ ଗୋଟେ କୋଉ ground ଆସିଲେ ଆପଣ କରିପାରିବେ. But conditions are that ଯୋଉଟାକୁ ସବୁ ଯାକୁ ଆପଣ ଦେଖିବାକୁ ପଡିବ ଯେ these all conditions are to be satisfied. So one of such grounds, one of such 7 grounds, plus all conditions that we will discuss today. So conditions are mandatory. ଏଇ ସବୁ condition ଗୁଡାକୁ ଗୋଟେ court fulfill କରିବାକୁ ପଡିବ while granting an injunction. ଯଦି ଏଇ ସବୁ ନଥିବ ତାହେଲେ injunction ଦେବାର question. First is prima facie case. Prima facie case ମାନେ case made out from the face of the suit. ଯୋଉ ଆପଣ ଯାହା ଆପଣ ଆଣିଥିଲେ ଆପଣଙ୍କର application ଆଣିଥିଲେ, in that from the face of that there must be a prima facie case made. The petitioner ଯିଏ case ଟା ଯିଏ ଏବେ injunction ପାଇଁ apply କରୁଛି, he must satisfy the court that how he has a prima facie case. The burden of proof lies on him to show that he has a prima facie case, that is a case which is being made out from the face of it. ତାମାନେ ଉପରୁ ଦେଖିଲେ ହିଁ ଆମକୁ ଲାଗୁଛି that there is a case in favor of the plaintiff. ତାମାନେ ଆମକୁ ଭିତରକୁ କେତେ ଯିବା ଦରକାର ନାହିଁ, ଏଭିଡେନ୍ସ ଯିବା ଦରକାର ନାହିଁ, just ଉପରୁ ଦେଖିଲା ବେଳକୁ ହିଁ there is a prima facie case being made out against in favor of the plaintiff. That is there. Next is irreparable loss. Irreparable loss is, that is what? That is a material injury. Irreparable loss, ଆପଣ ଭାବୁଥିବେ irreparable loss ମାନେ ଗୋଟେ loss ଯୋଉଟାକୁ repair ହେଇପାରିବନି. No, that is not true. Irreparable loss ମାନେ a loss which cannot be compensated in terms of money or which cannot be adequately compensated in terms of damages. So ଆପଣ pecuniary value ରେ ଯଦି ତାକୁ compensate normally court ସେଇଆ ହିଁ ଦେଖନ୍ତି that ଯଦି ପଇସା ଦେଇକି ତାକୁ compensate କରିହବନି then it is an irreparable loss. ତା ମାନେ I'll give you an example. ମୋର ଗୋଟେ court ରେ ଗୋଟେ ଏମିତି case ହେଇଥିଲା. there was an old lady who was a widow. ଏବେ ତାର wife ମାନେ ତାଙ୍କ husband ମରିଗଲା ପରେ ସେ ଥିଲା ତାଙ୍କ ପୁଅ ସହିତ. Now the son also died. Now when the son died, ଏବେ ବୋହୂ କଣ କଲା, ଦେଖିଲା ତ ପୁଅ ବି ମରିଯାଇଛି, ଶ୍ୱଶୁର ଆଗରୁ ମରିଯାଇଥିଲେ, ଏବେ ଶାଶୁକୁ ସେ କହିଲା ଘରୁ ବାହାରି. ସିଏ ମାନେ ସେ ଯୋଉ old woman, she had come to my court and she had no other expectation other than being allowed to stay in that house. So ତାର କିଛି ଏକ୍ସପେକ୍ଟେସନ ନଥିଲା କୋର୍ଟକୁ, ସେ କହୁଥିଲା କି ଖାଲି ମତେ ଘରେ ରହିବାକୁ ଦିଆଯାଉ, କାହିଁକିନା ମୋର ଏବେ I have nowhere to go. ମୋ ନାଁରେ ତ କିଛି ନାହିଁ, ସବୁ ପ୍ରପର୍ଟି ପୁଅ ନାଁରେ ସେ କରିଦେଇକି ପଳେଇଛନ୍ତି ଯାହାବି. Now I have nowhere to go. ଏବେ ଯଦି ପୁଅର heirs ମାନେ they are trying to remove me from my paternal house where I have been staying for last 30 years, now I'll not be in a position to go anywhere. So in that case, whether that can be compensated by money, my question is this: am I genuinely feel that cannot be compensated in terms of money. That is an injury which or loss which cannot be compensated adequately by damages or pecuniary standard. So ଆପଣ ତାପରେ ଘରୁ ବାହାରି ଗଲା ପରେ ସେ ଯୋଉ ଦରଦର ଭଟକିବ ବୁଢୀ, ସେଇ ତାକୁ ଆପଣ କଣ ପଇସା ଦେଇକି ଆପଣ ତାକୁ ଲସ୍ ଟାକୁ ଡ୍ୟାମେଜ ଟାକୁ ଆପଣ ଯୋଉଟା ଡ୍ୟାମେଜ ହେଇଗଲା ତାକୁ କଣ୍ଟ୍ରୋଲ କରିପାରିବେ? If that cannot be done, then that is a good ground, that is a condition which has to be satisfied while granting an injunction. So second is irreparable loss. Irreparable loss, not to be confused with loss which cannot be repaired. It is just talking about a loss which cannot be compensated adequately. Got my point? So this is what irreparable loss is. Now coming to the third condition, that is balance of inconvenience. See, many people, in fact, the English law and the Indian law says that it is balance of convenience. तामाने convenience टा जहाँ पटरे ताकू देखिबा हम कहाँ पटरे अछि तामाने गोटे इट इज जस्ट लाइक ए तराजू जेंति आपण गोटे वेइंग स्केल रे एपडे प्लेंटिफ को बसेबे सेपडे डिफेंडेंट को बसेबे आ देखिबे दैट को पटकू से जो वेइंग स्केल टा जाउची से तराजू टा को पटकू जाउची सो अकॉर्डिंग टू दैट यू विल डिसाइड but I believe the correct word would be balance of inconvenience. So basically से तराजू रे आपण जो प्लेंटिव और डिफेंडेंट को रखी मापिबे एया देखिबे जे काहाकू अधिका इनकन्वीनियंस होची ता माने जदि मु रिफ्यूज करूची इंजंक्शन टा जदि इंजंक्शन टा दोनी ताहेले कोन जो प्लेंटिफ जी एबे इंजंक्शन पे अप्लाई करूची ताकू कोन बहुत इनकन्वीनियंस होची की greater inconvenience is caused to that person और यदि मु दोची इंजंक्शन ताहले ग्रेटर इनकन्वीनियंस होची कि ऑपोजिट पार्टी सो बोथ आई हैव टू कंपेयर so सेठी comparative inconvenience caused to the party that is to be seen so that means if by refusing injunction greater inconvenience would be caused to the petitioner then injunction will be granted and if by granting injunction greater inconvenience would be caused to the opposite party then it is to be denied. So in the said question जो आपनकर ओल्ड वुमेन कर जोडा एग्जांपल दउथली रियल लाइफ केस लो सथरे आपण देखंतु जदी मु एबे माने ओल्ड वुमेन हु हैज कम he is the petitioner and the other person जो मन तारो एयर छंजु मन ताकू डिस्पोजेस कर दवा को चाहू चंदी they are the opposite party now मु ताकू weighing scale रे पकेली पडे बुढी को रखिली सेपडे अदर एयर्स को रखिली now I am seeing that जदी मु इंजेक्शन दउची ताले ऑपोजिट वन कर बेसे बेसे कोन हबो ताको घरे आ गोटे बुढी लोकटे रहि सो केते भी इनकन्वीनियंस हे गला बट मु जदी इंजेक्शन दोनी ताले एबे बुढी विल बी लेफ्ट एट द मर्सी ऑफ नो वन ही विल बी लेफ्ट आउट तार गोटे रूफ रहिबोनी her right to life will be violated so who is at a greater inconvenience here so balance of inconvenience is to be seen like that कि काहाकू बेसी इनकन्वीनियंस होची जदी ता अगेंस्ट रे ऑर्डर टा जाउची तो बेसिकली एति आपन देखियार अछि जदी इंजंक्शन दिया होची ग्रांट होची रिफ्यूज होची अकॉर्डिंगली आपन देखियार जे ग्रांट हेले काहाकू बेसी इनकन्वीनियंस होची किबा रिजेक्ट हेले काहाकू बेसी इनकन्वीनियंस सो जदी बेसी इनकन्वीनियंस जहा को होतबो ताहा फेवर रे देबे ता माने ता ऑपोजिट कामडा करियो जदी आपण ग्रांट करले देखुचंती जे इनकन्वीनियंस बेसी होची ऑपोजिट पार्टी तो आपण ग्रांट न करी की डिनाय करिवे इंजंक्शन बट जदी देखिले ग्रांट न करिया चक्कर रे आपण ग्रेटर इनकन्वीनियंस होची पिटिशनर को then in that case you will grant it I hope I am clear balance of inconvenience is this fourth condition is bona fide conduct by the applicant so it is as it is an equitable relief so this is injunction this temporary injunction is an equitable relief law of equity ru asiji that in order to preserve the property in order to make sure that the property which is in dispute is not wasted you are granting an injunction so in that manner bona fide conduct of the applicant is to be seen so that means जदि एबे plaintiff तार निजर डिले पई किछि कर नथिबो और ता पार्ट रे किछि भूल रहि जाइथिबो और एक्विजिशंस माने कोन और इन दैट केस जदि से गोटे टाइम पई plaintiff कोन करछि ना माने दो ताकू इच्छा नथिला डिफेंडेंट करू बट स्टिल से अलाउ कर दिछि किछ समय ताले सेटा एक्विजिशंस हे गेला तो से इन दैट केस आल्सो इट विल बी रिफ्यूज्ड so the conduct of the petitioner or conduct of the applicant that is of paramount importance so it will be seen whether he was having a bona fide conduct whether he has come to the court with clean hands whether he has no latches whether he has no delay see taku waive kar dechi ki se right taku or accuses kar dechi ki all of this has to be seen before granting an injunction or under this order so these are the again these are we can discuss the four conditions which are to be followed these are the conditions Now we'll discuss the principles to be followed by the court while granting an injunction. These are the conditions to be satisfied in order to grant an injunction. Now court has to see, has to also consider all these principles to make sure that an injunction is not a bad order. An injunction order, if granted or rejected, is not a bad order. You have to see certain principles whether they are followed. First is that it has been given that it must be a judicial discretion and not an arbitrary discretion. Discretion रे दबो कोर्ट, but आपण judicially कौन पे reason देले, कौन पे आपण दौचंती, माने judicial reason. तमने आपण लिखिबे जे एई ground पे मु भाबुची जे balance of inconvenience, irreparable loss and a prima facie case lie in favor of this person. तो तापरे मु देखुची जे bona fide रा भी interest अछि. So in that ground I am inclined to grant. This court is of the view that an injunction would be a sufficient order. So ଏଇଠି ଆପଣ କରିକି ଆପଣ injunction ଦେଇପାରିବେ. So it must be a judicial discretion, not an arbitrary discretion. Dalpat versus Prahlad case रे कथा. And again it is saying that as it is an equitable relief, it should not be granted if causes administrative inconvenience or public mischief. For example, election case रे normally election दिया जाएनी କାହିଁକି ନା ଆପଣ ଯଦି ଏଠି କରିବେ ତାହେଲେ administrative inconvenience ହବ କାହିଁକି ନା ଥରେ election ହେଲାଣି ପୁଣି ଆଉ ଥରେ ଏବେ election date fix କର ପୁଣି ଆଉ ଥରେ କର ତ most of the times election ରେ ଆପଣ injunction ଦେଖି ହଁ ଯଦି there is an irregularity you decide the suit but injunction ଆପଣ allow କରିବେନି election ରେ why the reason being that it will be causing administrative inconvenience or if it causes public mischief then also it will be rejected. Of course, status quo can be granted. There is always a divided opinion that whether status quo granted in an injunction is a valid order. तामाने दी पार्टी कहीं किसी करीबनी in respect of the property. Whether that is a valid order. The principle is yes, status quo can be granted. Again, another thing, जो हमको ground देइथिली जे एई जो 17 ground रे हेले ही हबो से जो 7 number ground ता कोची any other ground as deemed fit by the court. So accordingly, if it is not covered under order 39 then still can be granted under section 151 CPC. 151 CPC you must know that is dealing with inherent power of the court that gives wide power to the court. So basically in under CPC what a munsif or civil judge junior division with the junior division nahi khali civil judge has power which is in parlance to the high court, honorable high court as well, because inherent power it is so you can do anything. सेठी inherent power जेतले criminal side रे देखुछ 482 रे normal criminal court को नहीं सेठी खाली high court रे inherent power but here 151 CPC grants power to a normal civil court any civil court so thus order 39 जदी cover न होची still भी आपण दे पाए. Also the general principle is that notice should always be given before giving an injunction. Before granting or refusing an injunction, notice should be given to the party against whom the injunction is being issued. So it आज में डिस्कस करिबा मॉर्गन स्टैनली वर्सेस कार्तिक दास ए केस टा गोटे बहुत इंपोर्टेंट केस टे एथरे along with this principles आउ किछि प्रिंसिपल नुवा प्रिंसिपल फॉलो करिया पई जोडा को कोर्ट कहितले जे एई सब प्रिंसिपल्स को भी आपण you have to keep it in mind. The court had observed that is serious mischief to be caused to the applicant or not. The applicant को serious mischief होउची ना नहीं prime facie case ता against रो अछि ना नहीं सेउडा देखियो पड़ियो first. Second, if refusal would result in greater injustice or allow it. So basically सही कथा जो को आउ थरे कहै जे refusal कले greater injustice हबो और allow कले greater injustice हबो सेटा आपण देखियो पड़ियो. Time at which applicant first had notice of the act. So जेतले applicant करूची whether सीए तार delay अछि की whether he has come in clean hands तार ता पाटर किछि delay रहि गेले सेटा भी आपण देखिबे. If acquiescence is there then whether that has been done that has to be seen. Utmost good faith of the party. So good faith of the party that has to be there that has to be seen. There's whether the party who has come that has come in good faith or not. How do we principle कहले that ex parte injunction is for a limited time. Ex parte injunction जितले आपण देबे हम पढिबा ex parte injunction order 39 rule 3 रे ex parte injunction कोची जे normally notice सहित ही injunction दवा कथा order 39 rule 1 2 रे पढले but 3 रे कोची ex parte injunction भी देई हम. So ex parte injunction for a limited time सेटा भी Morgan Stanley केस रे कहला आउ कहला along with that the general principles that those are there जहाँ भी general principles थिला जे judicial discretion हवा दरकार granted should not be granted status quo देई परिबे other year ground देई परिबे notice देई परिबे prime office case थिला दरकार balance of inconvenience थिला दरकार irreparable loss थिला दरकार bona fide made हवा दरकार ये सब गुड़ाक करा बोली Morgan Stanley versus Karthik Das. What are the remedies if your injunction is granted or refused? First होची जदि refuse कराइची then it can be appealed against. Order 43 rule 1 R रे होची जदि refuse ହେଇची grant हेले सेतरे appeal ହେଇपरि refuse जदि ହେଇची appeal ହେଇपरि order 43 तापरे आउटे कोची कोन revision ହେଇपरिबो both case grant हो किबा refuse हो it is a case decided so it can be revised section 115 रे it can be revised but जदि आपण refuse करचंती ताहाले खाली appeal ହେଇपरिबो grant ହେଇतले appeal नै ex parte injunction रे जदि grant हेतिबो and it is not decided within 30 days then an appeal can be filed so normally आपण जानिबे appeal खाली refusal रे हुए but जदि ex parte injunction थिबो आउ 30 days भितरे decided हबनी then in that case it can be appealed against revision both case रे आपण करि परिबे refusal रे भी grant रे now coming to order 39 rule 3 that is ex parte injunction. The heading is missing here, ex parte injunction. That is the normal rule is that no injunction without notice. So basically, आपण normally injunction देला बेलकू notice दवा को बाध्य other party को आसीकी other party को सुनिबे and then only you will grant an injunction. That is in fact in the interest of principle of natural justice. You can't condemn a party without hearing him. So the normal rule says that no injunction will be granted without serving a notice to the party against whom such injunction is issued. But exceptional circumstances re, the court is of the opinion that the object of granting injunction would be defeated in the delay. So सेतिकी भितरे जितले notice देइकी आसला भितरे एते टाइम पळेबो सेतिकी भितरे the object of the injunction granting injunction would be defeated. ता माने एबे से एग्जांपल होची जे आजी मु देखिली जो पार्टीशन पई मु जो सूट अगेंस्ट पार्टीशन करथिली मो भाई से ऑलरेडी एग्रीमेंट करि सरलानी आ आजी से बिकियो बोली बसिची सो एबे जदि मु नोटिस देई की तापरे करिवि ए सेतळकू सबु आउ किछि नथिबो so in that case the object of granting injunction would be defeated by the delay that will be caused when serving the notice then in that case it will be spared with notice can be spared with the court can very well spare the notice but it must record reasons why it has spared the notice and why it is passing an injunction ex parte ता माने ताकू हियर न करी की ताकू नोटिस न दे की स्टिल काहे की आफ्टर ता काहे की दिया हला कोर्ट विल हैव टू रिकॉर्ड रीजंस एप्लीकेशन जदी करिवो ताहले कोर्ट कैन डू सो but only in exceptional circumstances if the court is of the opinion and that opinion must be judicial opinion that the object of granting injunction would be defeated in the delay caused. Of course, it is the delay order 39(3) re, if you grant an injunction, then you have to direct that the applicant has to send to the opposite party the copies of all the followings. That is, copy of the application of injunction, copy of the affidavit supporting it, copy of the plaint, and the documents on which he relies. All these things have to be given by the next day. By the next day, you have to supply to the OP and an affidavit to that respect. That means an affidavit saying that I have supplied these copies to the OP has to be filed. ଯଦି ନ ହବ ତାହେଲେ ଇଞ୍ଜେକ୍ସନ ଟାକୁ ଆଉ ଥରେ ୱିଥଡ୍ର କରାହବ ଆପଣଙ୍କୁ क्वेश्चन ଆସିପାରେ ଯଦି ଇଞ୍ଜେକ୍ସନ ଦିଆ ହେଇଥିଲା ଆଉ ତାକୁ डायरेक्शन କରାହେଲା that you serve all these copies to the opposite party by the next day ଏଟା କରାଯାଏ ଯେ फाइलिंग put up ଯେତେବେଳେ ଇଞ୍ଜେକ୍ସନ ଦିଆଯାଏ ଲାଷ୍ଟ ଲେଖାଯାଏ put up a letter for filing of requisites that means applicant has to serve copies of all these to the OP and then file an affidavit to that effect that he has served it if he doesn't do so then injunction can be again discharged or variation can be done to that effect. Time limit rule 3 रे कहला time limit केते ex parte injunction रो that ex parte injunction normally 30 days रे आपण ex parte injunction जे थरे देले ताले 30 days भितरे आपनको मेन एप्लिकेशन टाको सुनियो. Once you grant an ex parte injunction, you have to hear the main application and dispose. तामाने 39(1)(2) फाइल हेतिला. 39(1)(2) रे जोडा फाइल हला परे देखिले जे 39(1)(2) रे जेतु टाइम लागिवो नोटिस देला बेलू टाइम लागिवो. In that case you are probably the object of granting such injunction would be defeated. So 39(3) रे आपण देले. एबे 39(3) रे जो आपण दे देले एटा तामाने एबे आपनको 39(1)(2) रे एप्लिकेशन टा 30 days भितरे आपनको सुनिया को पड़िबो. जदि आपण न सुनी पारचंती न सारी पारचंती ताले you have to record reasons why you couldn't do so. So that is the time limit that 30 days परे भितरे आपनको सुनिया को पड़िबो आउ डिस्पोज करिया को पड़िबो द मेन एप्लिकेशन. Again disobedience or violation of injunction एठी गोटे कंटेम्प्ट भलिया पावर टे अछि जे नॉर्मली कंटेम्प्ट पावर न थाए नॉर्मल कोर्ट्स को पाखरे एक्सेप्ट दी हाई कोर्ट्स ऑनरेबल हाई कोर्ट्स एंड सुप्रीम कोर्ट्स बट एठी सिविल कोर्ट पाखरे अछि गोटे कंटेम्प्ट पावर ता जदी एठी गोटे ऑर्डर दिया हला इंजंक्शन रो आ से वायलेट कला जहा अगेंस्ट रे ऑर्डर ता दिया हितला से वायलेट कला ताहले ताको अरेस्ट भी करि परिबा आ डिटेंशन करि परिबा केते दिन पई 3 मंथ्स पई आउ भी कोन करि परिबा से जो प्रॉपर्टी alleged that can be attached for up to 1 year. 1 year पई अटैच करि परिबा 3 मंथ्स पई सिविल इम्प्रिजनमेंट भी ताको देई परिबा. एट सबले सिविल इम्प्रिजनमेंट देई परिबा. There is a question put to yesterday that civil prison is dealing with the cases where there is an order passed and you are defaulting that. Then in that civil prisons are usually given. But जो normal prison or criminal prison जोटा सेटा दिया जाय केते बेले जेतेले आपण गोटे ऑफेंस करूचंती then in that case you are put behind bars. That is a criminal prison. But एठी आपण civil prison दिया हबो because an order was passed and you did not obey that or you defaulted in doing that. Then in that case civil prison हबो. एठी 3 months परन देई हबो 1 year परन अटैचमेंट दिया हबो. आ जदी स्टिल भी आपण कंटिन्यू कले से जो disobedience ता then that property attached may be sold. प्रॉपर्टी जोटा अटैच हेतो ताको सेल कराई की तादरु कंपेंसेशन भी दिया हेतइबो इंजर्ड. तो इंजर्ड पार्टी को आपण कंपेंसेशन भी देई परिबे सेथरु प्रॉपर्टी अटैच को सेल करी. Now coming to discharge, variation or setting aside of injunction. Rule 4 रे कहूची it may be discharged, varied or set aside on application made by the party. So जदी आगुर गोटे इंजंक्शन दिया हेतिबो तापरे ओंडे एप्लिकेशन कला आउडे पार्टी जे नाइ नाइ एई ग्राउंड रे एटा को आपण वैरी करिया कथा इंजंक्शन टा को आपण काटी देबा कथा और वैरी करिया कथा then it can be done. Vacate भी करि परिबे जदी if the court is coming to the opinion that it has been done on false ground or false evidence देखि से इंजंक्शन टा ऑब्टेन कराई जाईची then it can be vacated as well. किंतु आउट एक क्लॉज दे देला जे जदी नोटिस थरे दिया हेची ताहले only on the ground of change in circumstances and hardship caused to the parties the injunction can be varied, discharged or set aside. Next is rule 5 कोची injunction against corporation. जे कोची जदी थरे गोटे कंपनी को दिया हला कि कॉर्पोरेशन को दिया हला then it is binding on all members and officers whose personal action it seeks to restrain. ता माने एबे मु कंपनी को देकी तापर सीईओ आउ जे ता अंडर रे अछंती समस्त को इंडिविजुअली दवा दरकार कंपनी को देले ता अंडर रे जो माने अछंती जहार पर्सनल एक्शंस आई एम सीकिंग टू रिस्ट्रेन those persons will be restrained as well. 95 CPC रे कहूची जदी insufficient ground रे you are obtaining an injunction then 50k पर्यंत compensation भी देई हबो. So this in a nutshell completes our discussion on order 39 rule 1 to 5 that is temporary injunctions. I hope all of you are clear. If still there is any doubt you may put it right. Pritiman has a doubt. Yes Pritiman.
सर नमस्कार. हेलो
नमस्कार
सर जो ए एनक्रोच करती बी रे प्रॉपर्टी आपण जो एग्जांपल गले सर से माने से एनक्रोच मतलब विदाउट कंसेंट रे इवन इफ ताको कहला पर मध्य से एनक्रोच करके चालती तो सर सेटा को सर स्टे ऑर्डर विल जो कौन सर टेम्परेरी इंजेक्शन ना मैंडेटरी इंजेक्शन सर
जो एनक्रोच करके जाउची सेतरे भी टेम्परेरी इंजेक्शन नहीं करा हो.
सर जो सर आपण तो कहले घरटा डिमोलिश हबो बोले सर सेटा सेटा तो स्टे ऑर्डर लगेले किछ हबोनी बोली जो कोतन सेटा आपण मैंडेटरी हबो ना टेम्परेरी हबो.
जदी घरटा डिमोलिश करिया कोचन दैट इज अ मैंडेटरी इंजेक्शन दैट इज सेटा सेतरे एक्चुअली हमर माने प्रोविजन नाही ऑर्डर 39 रे टू डू ए सर्टेन एक्ट एंड सेतरे कोची टू रिस्ट्रेन ए पार्टी फ्रॉम डूइंग समथिंग or any other order which can be passed according which is deemed fit by the court kohuji, but generally mandatory injunction दिया जाए. It is generally to make sure that ଯାହା ହେଇଯାଇଛି ତାପରେ ଆଉ କିଛି ନ. So demolish କରିବା ପାଇଁ ଚାହିଁଲେ mandatory injunction ଆପଣ କରିପାରିବେ, but order 39 ରେ it is talking about only temporary injunction, and that is not to do a particular act in a particular manner because the property is being disposed of or alienated or destroyed or anything of that sort.
ସାର୍ ମାନେ ସେ ଭିତରେ ମାନେ ଘରଟା ନୂଆରେ ହେଇଛି ଆଉ ଜଣ ଜାଗାରେ ସେ ଆସିକି ରହିନି ହେଲେ ମଧ୍ୟ ତାର ଇଞ୍ଜେକ୍ସନ ଲଗେଇଲେ ସାର୍ ଘର ହେଇସାରିଲା ଇଞ୍ଜେକ୍ସନ ଲଗେଇଲେ ମଧ୍ୟ ତାର ମାନେ କିଛିଟା ବେନିଫିଟ ଅଛି ହେଲେ ସାର୍ ମାନେ as per law.
ଆପଣ ମାନେ ଆପଣ do you have a like particular case in mind? Then if you say that ଯଦି କିଛି ଗୋଟେ ଆପଣଙ୍କର real life example ଅଛି ପୁରା fact କୁହନ୍ତୁ ତାପରେ ମୁଁ କହିଦେବି. Because
ହଁ
without
ସାର୍ ମୋର ନିଜ ଜାଗାରେ ଗୋଟେ ଜଣ ଏନକ୍ରୋଚ କରିଥିଲା ସାର୍ ତାକୁ ଇଭେନ ମୋର କନସେଣ୍ଟରେ ମଧ୍ୟ ତାକୁ କହିଲା ପରେ ମଧ୍ୟ ସେ ଶୁଣିଲାନି ତ କଣ୍ଟିନ୍ୟୁସ୍ କରି ଚାଲିଲା.
ତ ଆପଣ ଏବେ ଆପଣ କରିପାରିବେ, ଏବେ ଆପଣ ଟେମ୍ପରାରୀ ଇଞ୍ଜେକ୍ସନ କରିପାରିବେ, ଟେମ୍ପରାରୀ ଇଞ୍ଜେକ୍ସନ କରିପାରିବେ ଯେ ଏବେ ଆଉ ତୁ କରନି, ଯେତିକି ପର୍ଯ୍ୟନ୍ତ ଅଛି ସେତିକି ପର୍ଯ୍ୟନ୍ତ ହଉ, ଲାଷ୍ଟରେ ଟିଲ୍ ଫାଇନାଲିଟି ଯେତେବେଳେ ଆପଣ ଜଣା ପଡିଲା ଯେ ଆପଣଙ୍କ ଜାଗାଟା ଆଉ ସେ ରଙ୍ଗ ରେ କରିଯାଇଥିଲା ତାକୁ ଡିମୋଲିଶ କରାଯାଇପାରିବ, ସେଟା ଲାଷ୍ଟରେ ଆପଣ କରାଯାଇପାରିବ. ମାଣ୍ଡାଟୋରୀ ଇଞ୍ଜେକ୍ସନ ନର୍ମାଲି ପର୍ମାନେଣ୍ଟଲି ଯେତେବେଳେ ହବ ମାଣ୍ଡାଟୋରୀ ହବ, ଟେମ୍ପରାରୀ
ସେ ପୁରା
ଇଞ୍ଜେକ୍ସନରେ ମାଣ୍ଡାଟୋରୀ ଇଞ୍ଜେକ୍ସନ ହବନି.
ସେ ପୁରା ଘର କରିକି ମାନେ ସୁପର ଷ୍ଟ୍ରକ୍ଚର ସହିତ କରିଥିଲା ମାନେ ତାର ଇଞ୍ଜେକ୍ସନ ଲଗେଇଲେ ଭ୍ୟାଲିଡ ନା
ଇଞ୍ଜେକ୍ସନ ଲଗେଇଦେଲେ ଏବେ ଯେତିକି ଅଛି ସେମିତି ରହିବ, କେହି କାହାକୁ କିଛି କରିପାରିବେନି, ଷ୍ଟାଟସ୍ କୋ ଲାଗିଗଲା, ଏବେ ପ୍ରଫିଟ ଟା ରହିଲା. ଆଟ୍ ଦି ଏଣ୍ଡ ଅଫ ଦି ସୁଟ୍ ଯଦି ଦେଖା ହେଲା କି ଆପଣଙ୍କ ଫେଭରରେ ପ୍ରଫିଟ ଟା ପଡିଲା ଅର ସୁଟ୍ ଟା ଆପଣଙ୍କ ଫେଭରରେ ଆସିଲା, ଦେନ୍ ଇନ୍ ଦ୍ୟାଟ କେସ୍ ସେତେବେଳକୁ କୋର୍ଟ ଡାଇରେକ୍ଟ କରିପାରିବ that mandatory injunction now is given that you will demolish the property that was raised on the land of the plaintiff. So ସେତେବେଳେ କରିହବ, କିଛି ଅସୁବିଧା ନାହିଁ.
ଓକେ ଥ୍ୟାଙ୍କ ୟୁ ସାର୍.
Welcome. Any other question? Manas sir, yes.
ସାର୍ ପ୍ରାଇମା ଫେସି ଆକ୍ଚୁଆଲି ମାନେ ତାର ପୁରା ମିନିଂ ଟା ମୁଁ ବୁଝିପାରିଲିନି ସାର୍. ପ୍ରାଇମା ଫେସି କେସ୍ ଟା କେମିତି ଜାଣିବ ଯେ ପ୍ରାଇମା ଫେସି କେସ୍?
ପ୍ରାଇମା ଫେସି କେସ୍ ମାନେ ଆପଣ ଦେଖିବେ ଯେତେବେଳେ ଇଟ୍ ଇଜ ସୋ ଏଭିଡେଣ୍ଟ, ମାନେ with you ମାନେ ଆପଣଙ୍କୁ ଗୋଟେ ଲାଗିବନି କି ଯେ ମାନେ ଫର୍ଷ୍ଟ ଫେସ୍ ରୁ ଦେଖିଲା ବେଳକୁ ଆପଣଙ୍କୁ ଡାଉଟ୍ ହବା କଥା ନୁହଁ ଯେ ନାଇଁ ନାଇଁ ତା ଏଗେନ୍ଷ୍ଟ ତା ଫେଭରରେ କିଛି କେସ୍ ହିଁ ନାହିଁ. ସୋ ବେସିକାଲି ଆଇ ଏମ୍ ଗିଭିଂ ଆନ୍ ଏକ୍ସାମ୍ପଲ ଯେ ସପୋଜ ମୁଁ ଦେଖିଲି ମୁଁ ଯେତେବେଳେ ମୁଁ ଗୋଟେ ଆଣିଛି ପାର୍ଟିସନ ସୁଟ୍ ଟା କରୁଛି ଏବେ ଗୋଟେ ପ୍ରପର୍ଟି ଏଗେନ୍ଷ୍ଟରେ ପ୍ରପର୍ଟି ଟା ନେଇକି କରିଛି ଯେ ପାର୍ଟିସନ କରିବା ପାଇଁ ଚାହୁଁଛି, ତ ସେ
ଆଜ୍ଞା
ପ୍ରପର୍ଟି ଟା ମୁଁ ଦେଖିଲି ତାର ସେଡ୍ୟୁଲ ଲ୍ୟାଣ୍ଡ ଅଛି, ହଁ ଏବେ ତାକୁ ଏମିତି ତାର ବାପା ପାଖରୁ ଥିଲା ଆଉ ତା ବାପାର ନାଁ ଟା ରେକର୍ଡ ହେଇଛି, ତ ହି ହାଜ ଏ ପ୍ରାଇମ୍ କେସ୍. ମୁଁ ଏବେ ଦେଖିଲି ଯୋଉଥିରେ କି ଗୋଟେ ଆରଓଆର ଦଉଛି, ଗୋଟେ ପଟ୍ଟା ଦଉଛି ଯୋଉଥିରେ କି ତାଙ୍କ ବାପାର ହିଁ ନାଁ ନାହିଁ ଆଉ ତାଙ୍କ
ଆଜ୍ଞା
ଜେଜେବାପାର ନାହିଁ ଆଉ କାହାର ନାହିଁ, ସେଠି ମୁଁ ଦେଖିଲି କି ଯେ ଏଠି କଣ ଆଉ ଗୋଟେ ଏକ୍ସ ର ପ୍ରପର୍ଟି ଆଣିକି ଆପଣ ପାର୍ଟିସନ କରିପାରିବେ କି ତାକୁ? ସେଠି ପ୍ରାଇମ୍
ସାର୍
କେସ୍ ନୁହେଁ. ପ୍ରାଇମ୍ କେସ୍ ମାନେ ଫେସ୍ ରୁ ହିଁ ୟୁ ହାଭ୍ ଟୁ ମେକ୍ ଆଉଟ୍ that whether there is any chance of the plaintiff to win the, ଆପଣ ଏଠି ପୁରା ପ୍ଲେଣ୍ଟିଫ ଜିତିବ ନ ଜିତିବ ସେଟାକୁ ଆପଣ ଭିତରକୁ ଯିବାର ନାହିଁ. That will
ସାର୍
only be decided after adducing of evidence. ସେଟା
ସାର୍
ଆପଣ ଟ୍ରାଏଲ ର ପର ଷ୍ଟେଜରେ ଦେଖାଯିବ. ବଟ୍ ଏଠି ଫେସ୍ ରୁ ଦେଖିଲା ବେଳକୁ whether there is a case being made out, ଗୋଟେ କେସ୍ ଟେ ମେଡ୍ ଆଉଟ୍ ହଉଛି ନା ନାହିଁ. ଆପଣ କ୍ରିମିନାଲ କେସ୍ ରେ ଆପଣ ଏ କଣ୍ଟେକ୍ସଟ ରେ ବୁଝିଲେ ଆପଣଙ୍କୁ ବେଶୀ ବୁଝିପାରିବେ. କ୍ରିମିନାଲ କେସ୍ ରେ ପ୍ରାଇମ୍ କେସ୍ ଟା କେମିତି ଜଣା ପଡିବ. ସପୋଜ ମୁଁ ଏବେ ମାନେ ପ୍ରାଇମ୍ କେସ୍ ଟା କେମିତି, ମାନେ ଫର ଏକ୍ସାମ୍ପଲ ଗୋଟେ କହୁଛି ଏକ୍ସ ଏଗେନ୍ଷ୍ଟ ରେ ଗୋଟେ ଆଲିଗେସନ ହେଇଛି ମର୍ଡର,
ସାର୍
ବଟ୍ ଏକ୍ସ କଣ କରୁଛନ୍ତି ନା ସେଠି ଆପଣ ମାନେ ଇଟ୍ ଇଜ ଏ ପ୍ରୁଫ ଦ୍ୟାଟ କି ସେ ସେତେବେଳେ ଇଣ୍ଡିଆରେ ହିଁ ନାହିଁ, ବୁଝିପାରୁଛନ୍ତି ତ?
ବୁଝିପାରିଲି ସାର୍
ପ୍ରାଇମ୍ କେସ୍ ସିଏ ସେଠି ଅଲଗା ଗୋଟେ ଜାଗାରେ ଦେଖା ହେଇଛି, ତ ପ୍ରାଇମ୍ କେସ୍ ତା ଏଗେନ୍ଷ୍ଟ ରେ ହିଁ ନାହିଁ. ସୋ ଏମିତି ସିଭିଲ କେସ୍ ରେ ସେଇଆ ଯେ only face of it you are making out a case, from the
ସାର୍
face of it
ଆକ୍ଚୁଆଲି
you are seeing.
ସାର୍
Yes.
ଆକ୍ଚୁଆଲି କୋର୍ଟରେ ଶୁଣିଥିଲି ଦି ତିନି ଥର ପ୍ରାଇମା ଫେସି କେସ୍, ଆକ୍ଚୁଆଲି ବୁଝିପାରିନା ସାର୍ ପ୍ରାଇମା ଫେସି କାହାକୁ କହନ୍ତି, ସେଥିପାଇଁ ଆପଣଙ୍କୁ ପଚାରିଲି.
କିଛି ଅସୁବିଧା ନାହିଁ. ପ୍ରାଇମ୍ ମାନେ ଆପଣଙ୍କୁ ଦେଖିଲେ ହିଁ ଲାଗୁଥିବ, ମାନେ ଉପରୁ ଦେଖିଲା ବେଳକୁ ଲାଗୁଥିବ, ବେସିକାଲି
ସାର୍
ସିମ୍ପଲ
କ୍ଲିୟର କ୍ଲିୟର
ଟର୍ମ
ଅଛି
ହେଲା, ଉପରୁ ଦେଖିଲା ବେଳକୁ
ସାର୍
ଲାଗୁଥିବ ଯେ ଗୋଟେ କେସ୍ ଟେ ମେଡ୍ ଆଉଟ୍ ହଉଛି ନା, ତାପରେ
ସାର୍
ଆମେ ଯିବା ଅଦର ଥିଙ୍ଗସ୍ କୁ ଯୋଉଟା ଇରିପେରେବଲ ଲସ୍ ଆଉ ବାଲାନ୍ସ ଅଫ ଇନକମ୍.
ସାର୍
ଏନି ଅଦର ଡାଉଟ୍?
ସାର୍ ଆପଣ ଯୋଉ ସଣ୍ଡେ ଟେଷ୍ଟ କରିବେ କହିଲେ ଯୋଉ ଅନଲାଇନ
Yes,
ଟେଷ୍ଟ ମାନେ
yes. There
ଟପିକ
will be a test. There will be a test of long questions. That will be one long question, one problematic question from CPC. That is one, and then TP one long question and one problematic question. So each question will be
ସାର୍
12.5. So the total marks would be 50 marks. 50 marks.
ସାର୍
The length
ଅନଲାଇନ ନା
of the
ଅଫଲାଇନ ସାର୍?
That will be online. For now, let's stick to online. COVID cases are arising, so let's stick to online for some more time, and it will be online. How it will be done? It will be, in fact, the questions will be given. You have to write it in a piece of paper, on a blank paper. You have to write it, and then you have to click a picture or scan it and send it to the mail that will be given. And you have to do
Oh,
this. You have to do this. You have to do the test in 1 hour, and 15 minutes given will be given for you. I mean, 1 hour 15 minutes will be given for the entire test, and 15 minutes more to send this in. So entire test duration would be 1 hour 30 minutes. 1 hour 30 minutes ପରେ ଆପଣ send କଲେ it will not be valid. ଆମେ mail ରେ ଦେଖାଯିବ that ଏତିକି time ଭିତରେ ଆସିଛି. So 7 o'clock ରେ it will start. It will last till 8:30. 8:30 ଭିତରେ ଯେ submit କରିଥିବ, ଯାହା submit କରିଥିବ ସେଟା final. ଆପଣ submit କରିପାରିଲେନି, କିଛି error ହେଲା, it is your bad luck. ଆପଣ ପରେ କେବେ ପଠେଇଦେବେ, I'll evaluate it, but it will not be considered for the test purpose of test.
sir, COVID case पर माने case कम हला पर offline होबो sir exam.
It will be. I plan to do it, but not right now. Ticket ପରେ I'll notify you. I'll notify you all very soon.
Okay sir, thank you sir.
Welcome. Reena ma'am has a doubt. Reena Patel.
Sir, namaskar.
Namaskar ma'am. Can you please introduce yourself first?
Sir,
Reena
ମୁଁ
Patel. So Jagyasini ma'am is asking. Okay, first one by one. Reena Patel first. Please introduce yourself and ask the question.
Sir, myself Panda and working in Judiciary Department in Burger Civil Court.
Oh, that's great, ma'am. Oh, in which court you are attached to?
Sir, now I am bench clerk to JMFC Court.
I was posted at Burger. I mean, not posted. I was being trained at Burger. Do you know that?
Yes, sir. Yes, sir.
Oh, we had
And
a great
I was then suit clerk in the civil judge court, sir.
Oh, great. I must have seen you. I must be forgetting your face. I was being trained there in the court of SDGM. It was a great time. We were playing cricket with the staffs. It was a great time. I
Yes,
still
sir.
miss the Burger.
And moreover, we were sharing it in a single table. I was working and you were just.
Oh yes. I remember. Was I filling up the registers?
Yes, sir. You
Yes,
and
yes.
Resma ma'am and Anuradha ma'am, sir.
Yes. I remember now because I was sent by SDGM sir to be to make sure how the registers are filled, and I was doing that. Yes, I remember now.
Yes,
Okay.
then Subrat Acharya sir was
Yes, Subrat Acharya sir.
Yes, sir.
Okay, so what is your
intervenor
question?
means a third party to a suit.
कौन बोले?
Intervenor means a third party to a suit.
Intervenor will not be, in fact, a third party to the suit. କାହିଁକି ନା ତାର ଏଠି interest ଅଛି.
Yes.
You getting it? When I said third party, that means a person who has no interest is a stranger to the suit. If the intervener ହେଇ ସାରିଲାଣି, whether against that person an injunction can be granted? Yes, the answer would be yes. Intervener is third party ନାହିଁ, କାହିଁକିନା ସେ ଏବେ intervene କରିକି he has himself made him a party. କାହିଁକିନା intervener ତ ନିଜ ହିଁ ନିଜକୁ କରୁଛି ନା. So he is saying that I am interested. Right now, if he is doing an act which is coming under all of these grounds, then he can be barred from doing such act.
Yes, sir. Sir, in that case, he can also apply for injunction.
That's a good question. But no, he cannot apply for an injunction. The answer is either plaintiff or defendant will apply for the injunction, because intervener is not seeking any right. He is saying that I am just observing, I am just seeing if any right is violated. I have no right as such which I am challenging or defending. Intervener ସେଠି ମୁଁ intervene ହେଇକି ରହିଛି କାହିଁକି? Because I'm witnessing whether ମୋ property ଉପରେ କିଛି କରିଦେବେ ତ ଏମାନେ, ମୁଁ ତା ପାଖର property ଟା, ତ ମୁଁ ଭାବୁଛି କାଳେ ସେ କରିଦେବେ କି? So in that respect I am just a party, ମୁଁ ନିଜକୁ add କରିଛି. तो intervener against ରେ ଆପଣ ଯଦି ଚାହିଁବେ ଯେ intervener ଯଦି ଏବେ ମୋ ଇଏରେ ପଶିଲାଣି, so then ସେଠି ଆପଣ କରିପାରିବେ. But ଯଦି intervener ନିଜେ ଚାହିଁବ ସିଏ କରିପାରିବ.
So there was a case of execution that was of 1983, and from the Supreme Court it has been directed that it will be the property should be handed over to the DHR, decree holder.
Yes.
And the intervener was claiming that the property was his property as being adopted son. So in that case, he can apply for injunction or not?
He was claiming that it was his property.
Yes, being
Right.
being an adopted son of the decree holder.
But right now he's the entire status of the intervener is changing, because right now he's making a cross claim. Though he was added, right now the status of the party is changing. So in that case, yes, if it is of that sort, then probably yes, he can do it right now, because ସେଠି ତାର right କୁ ସେ ଗୋଟେ allege କରୁଛି, and that right is being violated.
Okay, sir. Sir, exactly the case is not being remembered to me. So, sir, I will study that one and ask.
Yes, yes. This is a case in your court or in apex
Sir,
court you are seeing?
in civil judge, sir. And it
Okay,
has
okay.
been decided by the
Please.
Supreme Court of India, and now it has been disposed of already.
Oh, great, great. Please come back to me with that, because it is a probably a gray area, that whether against or by intervener can an injunction be filed, or can an injunction be obtained against. That is a gray area. Anyway, you come back to me with that. Okay.
Okay. Thank you.
Thank you. Jagyasini ma'am, you had a doubt. You asked.
ଆଜ୍ଞା
Introduce
ସାର୍
yourself first.
ନମସ୍କାର
Namaskar. Introduce yourself first.
ସାର୍ ଆଡଭର୍ସ ପଜିସନଟା କେତେ ଇୟର୍ସ 12 ବର୍ଷ ନା 30 ଇୟର୍ସ
ଆଡଭର୍ଟାଇଜମେଣ୍ଟ ଆମେ ଲିମିଟେସନ ଆକ୍ଟ ରେ ପଢିବା, ସେଟା 12 ବର୍ଷ ଯୋଉ ଆପଣଙ୍କୁ ଯାହା ବି ଦିଆ ହେଇଛି ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଏଗେନ୍ଷ୍ଟ ରେ ଗୋଟେ ପିରିୟଡ, ପ୍ରାଇଭେଟ ପାର୍ଟି ଏଗେନ୍ଷ୍ଟ ରେ ଗୋଟେ ପିରିୟଡ, ଦ୍ୟାଟ ଇଜ ଫର ଆନାଦର ଟାଇମ। ଏତିକି ଖାଲି ଜାଣିବା କଥା ଯେ ଆଡଭର୍ସ ପୋଜିସନ ତ ପୁରା ଗୋଟେ ବହୁତ ବଡ ଡିସ୍କସନ ହେଇଯିବ, ବଟ ସେତିକି କହିପାରିବି ଆପଣଙ୍କୁ ଆଡଭର୍ସ ପୋଜିସନ ଯଦି ଆପଣ ପଚାରି ଦଉଛନ୍ତି, ସେଠି ଏତିକି ଯେ ଇଟ ଇଜ obtained when the party has no such ownership, but still he is claiming that ownership because he was in possession of that property for a period of time। ଯଦି ତା ଗୋଟେ ବହୁତ ଦିନ ପର୍ଯ୍ୟନ୍ତ ତ ଗୋଟେ ପିରିୟଡ ଉପରେ ରହିଯାଏ, ଯୋଉ he who sleeps over his right loses the right subsequently, ସେଇ ପ୍ରିନ୍ସିପଲ ରେ ଆଡଭର୍ସ ପୋଜିସନ ଅଛି। ବଟ୍ why did you ask it? ଏଟା କିଛି ଆର ସହିତ ଏବେ ରିଲେସନ ନାହିଁ, ବଟ୍ ଯେତେବେଳେ ଆମେ ଲିମିଟେସନ ଆକ୍ଟ ଡିସ୍କସ କରିବା, ଆମେ ଆଡଭର୍ସ ପୋଜିସନ କୁ କରିବା।
ଥ୍ୟାଙ୍କ ୟୁ ସାର୍
Okay, what, please introduce yourself ma'am।
ସାର୍ ମୁଁ କଟକ ପ୍ରାକ୍ଟିସ କରୁଛି ଆଡଭୋକେଟ
Okay, okay, great ma'am। Manas sir, do you have a doubt? Have you raised the hand or not? Raised it by
ହଁ ସାର୍
mistake।
ମୁଁ ପଚାରି ସାରିଥିଲି।
Okay, Dharitri has a doubt. Please ask।
ହ୍ୟାଲୋ ସାର୍ ନମସ୍କାର
ନମସ୍କାର Dharitri ma'am, tell me।
ସାର୍ କାଲିକାର ଟିକେ ପଚାରିଥିଲା ଯଦି ସୁଇଟେବଲ୍ ହୁଏ ଦେନ୍
Yes,
ପଚାର
yes, yes, please।
ଅର୍ଡର 38 ରୁଲ୍ 11 and 11A reattachment in execution ସାର୍ 11 ଏ ସାର୍
Rule 11, Rule 11A।
ଏ
Yes, tell me।
ସାର୍ 11A ଆଉଥରେ ଟିକେ ବୁଝେଇଦେବେ
ଦେଖନ୍ତୁ, ଆପଣଙ୍କୁ ସେ ତିନିଟା କହିଥିଲି ଯେ 7, 8, 11A, ଏ ସବୁ ଯାକ କହୁଛି that the rule 11A ଟା କଣ କହୁଛି? The provisions of this code applicable to an attachment made in execution degree। ସେଇ ସେତିକି ହିଁ କହୁଛି 11A ରେ, ଯେ ଯଦି ଆଟାଚମେଣ୍ଟ କଲା ବେଳକୁ ଯୋଉ ରୁଲ ଗୁଡା ଏକ୍ସିକ୍ୟୁସନ ରେ ଥିଲା, ରୁଲ 20 ମାନେ ଅର୍ଡର 21 ରେ ଆଟାଚ କଲା ବେଳକୁ ଯୋଉ ରୁଲ୍ସ ଗୁଡା ଆପ୍ଲାଏ ହଉଥିଲା, ଏଠି ବି ଆଟାଚ କଲା ବେଳକୁ ସେଇ ରୁଲ୍ସ ଗୁଡା ଆପ୍ଲାଏ ହବ ବୋଲି କହୁଛି। କଣ କହୁଛି? The provisions of this code applicable to an attachment made in execution of a decree, that means order 21, shall so far as may be apply to an attachment made before judgment which continues after the judgment by virtue of the provisions of rule 11। ତାମାନେ rule 11 ଆଉ rule 11 ରେ କଣ କହିଲା? Where property is under attachment by virtue of provisions of this order and a decree is subsequently passed in favor of a plaintiff, it shall not be necessary upon the application of for execution of such decree to apply for a reattachment। ତାମାନେ ଏଥିରେ ଏତିଆ କହିଥିଲା, ଯଦି ଆଟାଚମେଣ୍ଟ ବିଫୋର ଜଜମେଣ୍ଟ ହେଇଯାଇଛି, ଆଟାଚମେଣ୍ଟ ଥରେ ହେଇଯାଇଛି, ଏବେ ଡିକ୍ରି ହେଲା ବେଳକୁ ବି ଆପଣଙ୍କୁ ଆଉଥରେ ଆପ୍ଲାଏ କରିବା ଦରକାର ନାହିଁ ରିଆଟାଚମେଣ୍ଟ, ଏତିକି କହିଲା। ବଟ୍ ଏଥିରେ 11A ରେ କହିଲା, ଥରେ ସେଇ ଯୋଉ ଡିକ୍ରି ଏବେ ଡିକ୍ରି ହେଇଗଲାଣି, ଡିକ୍ରି ହେଇଗଲା ପରେ ଆପଣ ଆଟାଚମେଣ୍ଟ ଆଉଥରେ କରିବାର ଥିଲା, କିନ୍ତୁ ଯେହେତୁ ଆଗରୁ ଆଟାଚମେଣ୍ଟ କରିଥିଲେ ଆଉ ରିଆଟାଚମେଣ୍ଟ ଆପଣ କରୁନାହାନ୍ତି, ସୋ ଏବେ କଣ ହବ ନା, ଅର୍ଡର 21 ରେ ଯେମିତି ଆଟାଚମେଣ୍ଟ ରେ ଯୋଉ ରୁଲ ହଉଥିଲା, ସେଇ ରୁଲ ଗୁଡା ବି ଏଥିରେ ଆପ୍ଲାଏ ହବ ବୋଲି କହୁଛି। ସୋ ରୁଲ 7, ରୁଲ 8 and rule 11A all talks about mutatis mutandis application of order 21 to order 13। that is what it talks about। କି order 21 ରେ ଯେମିତି ଯେମିତି ହଉଥିଲା, 7 ରେ କହୁଛି ଯେ ମୋଡ ଅଫ ମେକିଂ ଆଟାଚମେଣ୍ଟ ଯାହା ଥିବ 7 order 21 ରେ ସେମିତି ହବ। 8 रे कहला एडजुडिकेशन ऑफ टू क्लेम जहा थिबो ऑर्डर 21 जहा होतो सेमति हो ऑर्डर 11 रे कहला गोटे अटैचमेंट जोटा हे रीअटैचमेंट हबा कथा बट रीअटैचमेंट दरकार हेलानी काहे की जे से प्रीवियसली अटैचमेंट हेतिला सेउडा केमति डील हबो सेउडा भी ऑर्डर 21 रे जेम दिछि सेमति डील हबो
आज्ञा सर क्लास 2 टा टिके कहते
क्लॉज 2
11A ର क्लास 2 टा
Clause 2 टा कुछ an attachment made before judgment in a suit which is dismissed for default shall not become एटा मैं in fact main कथाटा जे जदी थरे गोटे आपण गोटे करंतु जे गोटे अटैचमेंट ऑफ प्रॉपर्टी पई एप्लीकेशन दिया हेतला प्लेंटिफ देथिला एबे अटैचमेंट ऑर्डर हे गला जे डिफेंडेंट प्रॉपर्टी अटैच हे गला जेतु से बिक परियोनी तेरा रहिला अटैचमेंट एबे प्लेंटिफ आसिला प्लेंटिफ जतल न आसिला सूट इज डिसमिस्ड फॉर डिफॉल्ट now suit is dismissed for default the rule says jodi thore dismiss for default he gala tapare plaintiff subsequently comes and setting aside that dismissal for default and restoring that suit ebe se dismissal of default को set aside करके restore कर देला ता माने नु जे जो attachment previously हेतिला सेटा भी restore हे जिवो ebe plaintiff has to stand again on the footing and prove why an attachment is necessary. Did you get my point?
आज्ञा
merely because suit is revived suit टा revive हे गला जे dismiss हेतिला plaintiff आगु attachment टा obtain कर देतिला किन तापरे suit टा dismiss हे गला एबे suit टा जति revive हे गलानी ता माने नुह जे attachment भी revive हे एबे plaintiff has to again prove it before the court and court has to order the attachment once.
आज्ञा थैंक यू
Okay.
सर
Pritiman has a doubt?
सर कालीर जो लेक्चर रे सर रूल ऑर्डर 38 रूल 9 दा बुझा पड़लन सर रिमूवल ऑफ अटैचमेंट व्हेन सिक्योरिटी फर्निश्ड और सूट डिसमिस
बेसिकली सेइंग जदी आपण फर्स्ट कहिला कोन जे जतेबेले अटैचमेंट ता केतेबेले ऑर्डर करा होतला जतेबेले सीए फर्निश करनथला सिक्योरिटी सेतेबेले आपण अटैच करथि सेतुलु से सिक्योरिटी फर्निश करनथला किंबा रीजन दो नथला माने शोकस दो नथला काहे की सिक्योरिटी फर्निश करूनी देन आपण अटैच करथले एबे रूल लाइन रे कहू जदी सेही जोटा पई आपण अटैच करिथिले सेहीटा को से कंप्लाई कर दिला ताहले तो आ अटैचमेंट दरकार नै so that will be सेठी रिमूव करा हिजबा अटैचमेंट ता किमा जदी सूट ता ही डिसमिस हे गेलानी सूट जदी डिसमिस हे गेला ताले अटैचमेंट कोन दरकार तो सेठी भी दरकार नै तो दीटा केस रे अटैचमेंट जोटा आगुर ऑर्डर हेजी जो रूल 5 रूल 6 रे जो कहितला अटैचमेंट केतेबेले ऑर्डर हेजी कहितला सेही जो अटैचमेंट ता केतेबेले रिमूव हे परिबो जदी सूट ता डिसमिस हे गेला अटैचमेंट दरकार नै किमा जोथ पे अटैचमेंट हेतिला काहे कि ना डिफेंडेंट पे कंप्लाई करनथला से जो सिक्योरिटी फर्निश करनथला किमा शोकस करनथला से पे म अटैचमेंट करथली now he has done that he has complied to that so the attachment will be removed.
ओके सर थैंक यू
Okay. Anyone else? Okay, it's 8 o'clock. We shall. Okay, someone has a doubt.
सर
Yes, there is one.
sir is it necessary attachment before judgment all rules are mentioned in the exam
All rules not necessarily you have to mention. In fact, I will say attachment of property comes, but then you have to just remember कि केतेबेले attachment होची. Rule 5 रे कहला जे एटा हवा दरकार. Rule 6 रे कहला जदी से सिक्योरिटी फर्निश न कला ताहले ताको हम अटैच करछे. Rule 5 Rule 6 टा आपण जानले 7 रे तो कहूची मोड टा कहूची 8 रे को 8 टा in fact आपण लिखिया दरकार भी नै 9 टा कहूची रिमूव करिया पई केतेबेले रिमूव कर परिबे सेमती आपण इंपोर्टेंट सेक्शन इंपोर्टेंट रूल्स देखो मो हिसाब रे 5 6 7 9 7 9 ऑल दीज आर इंपोर्टेंट आउ सब जाक कहूची बट इट इज रूल 11 रो जोटा 11 ए रो जो 2 टा कहिले दैट इज आल्सो एन इंपोर्टेंट थिंग 12 टा गोटे इंपोर्टेंट एग्रीकल्चर
exception yes exception in 12 and 13
12 13 13 टा एते नै से स्मॉल कॉलेज टा करि परिबोनी सेती 12 टा मेन तापरे एमती आपण ओवरऑल आइडिया देवा को सब पढ़ाए बट दैट डजंट मीन कि आपन नेसेसरीली यू हैव टू रिमेंबर ऑल द रूल्स एंड बाय हार्ट देम इट्स नॉट नेसेसरी while we will complete all this I'll tell you again there will be in fact I'll tell you a secret ki how to mu आपन how to read CPC पढैतली and again पढेवा हमें पढिबा जे how to skip and what to skip while reading CPC बहुत गुडे जिंस आपन छाडी परिबे सेडा हम गोटे क्लास रे केबे नबे that will be in fact an interesting class कि को कोटा हम छाडी जाई परिबा कि एटा न पढले भी ठीक अछि माने आई एम नॉट सेइंग कि यू डोंट स्टडी सीपीसी ସବୁ ପଢନ୍ତୁ but ଯେତେବେଳେ ଲାଷ୍ଟ କୁ ଏକ୍ସାମ ପର୍ପସ ରେ କରିବାର ଅଛି you have to skip certain part. It's not possible order 21 ଯେତେବେଳେ ଆପଣ ପଢିବେ ସେତେବେଳେ ଦେଖିବେ 108ଟା ରୁଲ ସବୁ ଯାକ ମନେ ରଖିବା କୋଉଠି ପସିବଲ କେବେ ଆପଣ ଭାବି ପାରିବେ so all this ଖାଲି ପ୍ରିନ୍ସିପଲ୍ସ ହିଁ ଆପଣ ହିଁ ମନେ ରଖିପାରିବେ at the most or କିଛି important rules ଆପଣ ସବୁ ମନେ ରଖିବା possible ବି ନାହିଁ ତେଣୁ just take it like that important rules ଆପଣ ବୁଝନ୍ତୁ concepts ବୁଝନ୍ତୁ rule ଯଦି ଭୁଲି ଯାଉଛନ୍ତି for example if the question is asked ki attachment before judgment if you do not quote the rules exact rules quote न करी ଯେତିକି rule ମନେ ପଡୁଛି 5 6 7 ଏଟା ସବୁ ମନେ ପଡୁଛି 12 13 ଯୋଉଟା ଆପଣ ମନେ ପଡୁଛି 8 ଯୋଉଟା ମନେ ପଡିଲା ଲେଖିଲେ ଯୋଉଟା ନ ମନେ ପଡୁଛି ଖାଲି ପ୍ରିନ୍ସିପଲ ହିଁ ଲେଖିଦେଲେ ସପୋଜ ଏ କହୁଛି ରୁଲ 8 ରେ କହିଛି ଯେ adjudication ଯାହା କ୍ଲେମ ଥିବ ସେଟାକ ରୁଲ order 21 ରେ ଯୋଉ ରୁଲ ରେ ଯୋଉ ପ୍ରକାର ହେବ ସେଇ ଇଏରେ ହେବ ଆପଣ ପ୍ରିନ୍ସିପଲ ଲେଖିଲେ that is fine the examiner understands he is also a human he is not expecting you to write all the rules and oddly orders କିଛି ମାର୍କଅପ୍ କରିକି ଯେ ଆସିଥିବ ସେଟା କେବେ ପସିବଲ ହିଁ ନାହିଁ ଆପଣ ସବୁ ଲେଖିବେ ବୁଝିଲେ
ଆଜ୍ଞା ଆଜ୍ଞା ଥ୍ୟାଙ୍କ ୟୁ ସାର୍
ଚलो
ସାର୍ ନମସ୍କାର
ନମସ୍କାର ଜୟରାମ as a question
ସାର୍ ମୁଁ ପାରାଦୀପ ଆସୁଛି ମୁଁ ଷ୍ଟୁଡେଣ୍ଟ ଏବେ ଅଛି ସାର୍
ପାରାଦୀପରୁ ଓକେ ନାଇସ୍
ଆଜ୍ଞା ସାର୍ ସାର୍ ଆଜି ମୁଁ ଫାର୍ଷ୍ଟ କ୍ଲାସ୍ କରୁଛି ଗୋଟେ ଫ୍ରେଣ୍ଡ ଗୋଟେ ଲିଙ୍କ ପଠେଇଥିଲା ତ ମୁଁ କ୍ଲାସ୍ କରିବା ସମ୍ଭବ ହେଇବନି କଲେଜରେ ତ ଡେଲି କ୍ଲାସ୍ କରିବା ପାଇଁ ହେଲେ
ଆପଣ 7ଟା ବେଳେ ଫ୍ରି ନାହାନ୍ତି ୟାକୁ
ନା ନା ସାର୍ ମୁଁ ଫ୍ରି ଅଛି କିନ୍ତୁ ମୁଁ କାହିଁକିନା କିଛିଟା କ୍ଲାସ୍ କରିବାକୁ କଲେଜ ଯାଇପାରୁନି ତ କାହିଁକିନା କିଛିଟା ଅସୁବିଧା ସକାଶେ ତ ପଢ଼ିବା ପାଇଁ ଟିକେ ଅସୁବିଧା ହେଇଯାଉଛି ତ ଡେଲି କ୍ଲାସ୍
ଆପଣ
କରିବାକୁ
ଲିଙ୍କ ଡେଲି ପାଇବାକୁ ଚାହୁଁଛନ୍ତି ତ କ୍ଲାସର
ଏ ସାର୍
ଆପଣ you note my number 9599
95
9599
triple nine
959
triple five
38393
ସାର୍ 555
9599 38393
388
393
sorry sir 393
9599 38393 okay you ping me
yes
there I'll add you to the group and you'll get links every day
yes sir thank you sir
no issue anyone else we shall end the session I think it's beyond time 8:05 we'll study order 39 rule 6 to the rest of the rules and order 40 that is shorter order that will be completed within tomorrow I believe so be prepared the test will take place on Sunday all the best have a great night bye guys